Protector KWEBANE'S case against her suspension.
President Cyril Ramaphosa's lawyers told the court that KWEBANE had made no case. She argued that Ramaphosa should never have suspended her because he is conflicted as KWEBANE was probing the Phala Phala farm theft. DA lawyers argued that despite the seriousness of the Phala Phala saga, it cannot be allowed to detract from the fact that KWEBANE was lawfully suspended by the president after due process.
KWEBANE is challenging her suspension as well as whether the current parliamentary committee probing her fitness to hold office is a removal committee as stipulated in section 194 of the Constitution. Let's have this conversation now with Mpumelelo Zikalala, who is a legal analyst who joins us live now. Thank you so much to you for your time this evening, Kuzeni. The timing of the suspension continues to take center stage in this particular case. If you've listened to, the arguments in the past 2 days, as lawyers were arguing, in fact, that this was done just a day before that judgment by the Western Cape High Court. At the same time, the public protector was investigating the Phala Phala farm saga. How strong is this argument?
I don't think it's going to be that strong, because we must also look at when was this particular process started, or the suspension process started. It started way before, because a letter was sent way before the Phala Phala farm gate matter came about. And in fact, the suspended public protector wrote the first letter and said to the president, Mr. President, you are conflicted in this matter. I'm not going to respond to you. There are certain things in which you must look at, which you haven't looked at. And then there was a second submission by the suspended public protector, this time answering to the queries or to the correct, or dealing with the matter in a correct manner in which the president would have required. So in that particular case, the intention to suspend, or the inquiry of suspension, was initiated way before the Phala Phala farm gate came about. And there are no reasons which have been afforded by Advocate KWEBANE to sort of insinuate or suggest that the sole reason or the fast tracking of the suspension was due to the Phala Phala farm gate. Another thing that they could have done was to request extensive reasons from the president and say to him, yes, you in receipt of a letter that you've received to us, but we'd like to know the real reason of why you are suspending us. What did you look at? You want to interrogate those and check whether from a rationality basis it makes sense. Now, they haven't done so. They've gone to court basically limping on one foot. And that is what the court will have to deal with, and that is what they have to do at court. And based on that, the president is well within his powers to say, I'm suspending you before the start of this particular committee inquiry.
So then I'm listening to you. It doesn't sound then like you're convinced even with the argument around the timing of the start of these proceedings, because that was another central part of the argument. Because when you look at section 194, for example, it says the president may suspend a person at any time after the start of the proceedings of a committee of the National Assembly for the removal of that particular individuals. Her lawyers are saying that this particular process has not yet even started.
Now let's look at it from a practicality basis. What would be the basis or what is going to be looked at by the removal committee when a committee has set and decided on the merits that we have a public protector who has been found guilty of misconduct, incompetence, and all the other things which would appear in terms of the Constitution, in terms of the particular contraventions. That particular committee would sit and decide and say, this is the recommendation in which we are doing. Now, that particular removal committee cannot exist in which they are alleging, because practically it is not there. And that is the job of the National Assembly of saying, are we then endorsing the removal of this particular public protector? Or let's go back and decide. Who decides that the public protector must be removed? Is it the committee or is it the National Assembly? In this case, it is the National Assembly based on the recommendation of the particular committee. So the insinuation or the alleging that there are two committees that must exist before the matter goes to the National Assembly, again, to me, it's not that convincing. It may be that when you read from the text of the Constitution, it says that it's the removal of that particular individual. But I do not think that the intention of the legislature was to create two processes or two inquiry processes before you get to the National Assembly. Because the most important question, the pertinent question would be, what is the removal committee looking at? Because a decision has already been taken that a person has already engaged in instances of misconduct and incompetence, or does not know or does not have the capacity to handle the office of the public protector. So for me, that particular argument, again, I don't think it's going to hold water.
And it's very interesting because, I mean, if if you listen to these arguments, as you say, it also sounds like there needs to be two committees here, and you say that is not what needs to happen here. But let me get your thoughts on this one then, because they're raising the issue of the letter that the Speaker then sent to the President that, the impeachment process is underway. They say that this is legally wrong and this letter should have not been relied upon. Are they correct?
Let's look at it this way. How else is the President supposed to know that there are certain proceedings which are taking on or proceeding under the banner of Parliament? And it is a section of Parliament which is taking on those proceedings. So, ordinarily, or it is almost incidental that the Speaker would have to write to the President. As a person who presses the green button of hiring and firing the public protector and say, Mr. President, since you are the one in which the public protector is hired or is fired by you, you must note that we are dealing with this particular process at the end of the day, and at the end of the day we are going to need your adjudication, or you may need to come in and deal with this matter at a later stage. So we are just appraising you that this particular matter is going on, and it is up to you whether you want to take the information and do all other things or not. But the President was prudent in this matter because he does not say to the public protector, based on the sole information which I've received from the Speaker, I'm suspending. He goes back to the public protector and says, please give me reasons of why shouldn't I suspend. It is on that basis that the public protector should have gone to court and said, I want to carefully or comb through a fine comb the reasons of you suspending me, other than the other technicalities that are there. Don't doubt the powers which are there because the Constitution is quite clear. But look at whether the reasons of exercising those powers were adequate enough or are such that at the end of the day they warrant a suspension, rather than saying to a person, well, you can go to court and go to and attend this particular committee while remaining the public protector of South Africa. There's not going to be any hindrances or any disturbances which are going to take place. I'm allowing those particular reasons. So for me, I think the public protector should have concentrated on the reasons of why the President was suspending her instead of the powers of the President suspending.
Judgment has been reserved in this particular matter. Whichever way it rules, the Western Cape High Court, that is, does this have a bearing, you think, on the proceedings in Parliament?
No, they're not going to have any bearings. Let's look at what they're mainly concentrating on. They're basically saying, we're only dealing with the suspension at the end of the day. We're not dealing with the proceedings which are taking on at the Parliament. That particular matter is done and dusted. I think we've gone up to the Constitutional Court, and the Constitutional Court has said that that particular committee must continue. The only proviso for the change in the initial rules is that the public protector must be represented, which in this case she is represented. So that particular committee in this proceeding is still going to go on. They are still going to be able to investigate whether the public protector's conduct amounts to misconduct, does she have incapacity or is she incompetent in terms of doing her job. So that particular inquiry is going to continue. But it does have its own challenges, which at a later stage, when taken to court, maybe she may have a leg to stand on in terms of the procedure being used, especially also on the side of biasness of those particular committee members. For me, it is made up of committee members which, from an innocent bystander's point of view, they've already concluded in whether the public protector is guilty or not. So no matter what she says, she's not going to be able to convince them otherwise.
So I suppose then that argument that she made at the beginning of the proceedings through her lawyers, that some of those that are taking place, are taking part in this particular proceedings, have already made their, your predetermined outcomes, because these are politicians who have also been commenting on this matter on the public platform. So listening to you then, should she decide to take that particular assertion further, she may then be successful in court, especially now at the back of the Speaker even asking the DA's Milam, for example, to, really referring the matter to the lawyers to clarify whether there's no conflict in him being present in those proceedings.
Definitely. Maybe let's first look at the element of biasness. The courts have said, you look at it from an innocent bystander's point of view. Is there a reasonable suspicion or a reasonable grounds in the complainant's mind that these people already they are going to be biased against you? Now let's look at who is the main complainer or who filed this particular complaint. It is a Democratic Alliance. At the end of the day, they are part and parcel of this parliamentary committee. the people that are there, yes, they're members of the National Assembly. Yes, on paper, they may swear their allegiance to the Republic of South Africa, not the political party. But you can't divorce the fact that they're sitting in those chairs on the basis, on the wages of being members of the Democratic Alliance and representing the Democratic Alliance in Parliament. So the question would be, when do you divorce the mandate of your political party and the mandate or the job in which you're supposed to do within Parliament? So at the end of the day, already in the eyes of the public protector, she was well within her powers. And it was a very strategic move on her side to then say, before we even start, I want to place it on record that I do not feel that I'm going to be judged or the merits are going to be assessed fairly, because you are the complainant and the referee or the adjudicator in the same matter. So how likely is it that you are going to come back and say, I was wrong, or we were wrong as the Democratic Alliance? We have a perfect public protector who has no flaws, who has been doing everything according to what the books say and in compliance with the legislation. There are no flaws in which we are going to see against you. Please continue to do your job and protect the members of the public of South Africa. So if those chances are limited, especially from the side of the public protector, then definitely she has a lot to stand on when she takes this matter on review. Another thing is the methodology or the process in which they've used. They want to use a quasi-judicial process, and they want to wash it down and open it up as if it's more of a discussion or a brainstorming session. Can't work that way. At the end of the day, you have to have rules so that you're able to assess what type of matters are being elevated for you to assess and what are those in which you are going to disregard. Which is why you have a problem of saying you then have an open spectrum of witnesses which are being invited, and some of them which are not going to assist this particular committee into reaching a decision. So they haven't done a proper way of saying how we're going to handle this particular committee procedurally, so that at the end of the day it gives the results in which you are supposed to have.
And listening to what you're saying, then they are in a vulnerable position when it comes to legal challenges. Then when one looks at the road ahead, very briefly as we wrap up, how then do they begin to ensure that the composition of this particular committee is such that is free from perceived bias? Because as you say, there doesn't have to be proof of bias. It's just simply the feeling, the thought enough from the sidelines is enough to say that there may be bias here. What should the composition be?
They should go back and adopt a quasi-judicial process of handling this particular committee and say to it, yes, we do not want to turn it into a court of law, but we want the rules of natural justice to apply. We want the rules of what the merits are going to be looked at to be very clear in terms of the witnesses which are going to be called in. We also want to be clear on that one. Us as the adjudicators, the presiding officers, at the end, or the arbiters at the end of the day, we are going to ask questions which are going to be crisp and only deal with the matters that have been leveled on us. We are not going to partake in the evidence submission of all these processes. And we are only going to pronounce it on this matter at the end and not during the process. The last meeting that they had, to me, was quite shocking, because how do you sit and analyze evidence in a certain matter which is still proceeding? The public protector may then come back with a whole new set of evidence. There are other witnesses that may come back and provide evidence which is going to overturn the evidence that you've heard now. So for you to sit and adjudicate on that evidence and even come to a determination of who's telling the truth and who's lying, you've tainted the process. It's not going to be fair anymore. So for them, they really need to go back to the legal advisors who are going to say, how do we save this particular process in the work of the committee, just to make sure that at the end of the day we adhere to the core of the basic legal principles, because we don't want this process to be tainted or to be overturned by a court of law once it is done.
All right, Mr. Zegalala, thank you so much for your time this evening. Certainly a lot of thoughts to ponder on there as we look at how vulnerable this process in Parliament